Since before the medical marijuana law came into effect here in Michigan, our firm only handles marijuana cases and clients, and I can say that there is a lot of problem with law enforcement, but I'm not here today to speak about law enforcement. I want to speak about SB660. I think that SB660 is an expensive diversion. It is ineffective completely without any federal rescheduling. Federal rescheduling is the holy grail for us in the medical marijuana community and in the general marijuana community, in that without federal rescheduling, there can be no significant change in the federal level. A pharmaceutical preparation is something that can be prescribed by a physician and can be filled by a pharmacist. Marijuana does not meet that categorization, nor will it anytime soon. In order for a physician to be able to prescribe marijuana, it needs to be listed in the PDR, the physician's desk reference, where all pharmaceutical drugs are listed, so that a pharmacist can go and look and fill a particular prescription. So a doctor can't prescribe it, a pharmacist cannot fill the prescription. So this really is a waste of time unless and until federal scheduling changes. It would be far better to pass a resolution demanding that the federal government, that the United States Congress, reschedule marijuana. Or in the alternative, pass a bill requiring our state attorney general to sue in federal court to change the scheduling of marijuana. Clearly, the citizens of Michigan have determined that marijuana has medical use. One of the federal criteria for Schedule 1 is that it has no medical use. Those two things cannot coexist. And so really, our state should be suing the federal government for rescheduling. But unless and until we have rescheduling, this is pie in the sky. So we should spend our time instead on something like the Provisioning Center Bill, HB 4271, and the Extracts Bill, HB 5104. Since the Michigan Supreme Court ruled in the case of McQueen in February, patient-to-patient transfers are clearly illegal. Caregiver-to-caregiver transfers are clearly illegal. The only place a patient can get medical marijuana is to grow it themselves or to get it from their caregiver. And those caregivers are limited to 5 patients and to 72 plants. That's 12 plants per patient, assuming they themselves are a patient and they have 5 other patients. 12 times 6 is 72. Our law was specifically designed so that any one individual would have no more than 72 plants, specifically to keep the federal government not interested. You should know, if you don't already, that if you're convicted of growing 100 plants under federal law, it is a 5-year mandatory minimum sentence, not probationable. 1,000 plants is a 10-year mandatory minimum. So are we going to encourage large corporations to grow more than 100 plants while it's still a federal 5-year mandatory minimum? I don't think that that's a very wise idea. So the McQueen decision in February of 2013 basically foreclosed transactions between and among patients. It made all of the dispensaries in Michigan of questionable legality. In July of 2013, a case named Carruthers, which has been mentioned, determined that extracts are illegal. And everything that you've heard from the Cannabis Cancer Project and from Gersh Avery and other people are talking about how they are using extracts and how those are the most beneficial medicine. And so what we have is we've allowed the Supreme Court of Michigan to prohibit the most beneficial use of marijuana. Please, whatever you do with this bill, it doesn't make any difference. Let's get some dispensaries open in Michigan so that patients have choice and selection and the medicine that they need. Thank you very much. I am happy to answer any questions, and for your information, NORML is the National Organization for the Reform of Marijuana Laws, and I am the state director in Michigan, and it is our desire to see the marijuana laws repealed.
Amen.
Thank you. Are there any questions?